Hello everybody. Good evening. Good evening. Welcome. Hello. Good to see you. Hello. I'm just a few minutes early just to make sure the notifications can go out. But welcome in everybody. I really hope you had a great weekend. Hopefully your weekend has been going well. Let's see here. Here we go. Yes. Oh, good evening. Hello. I am on. I'm just a little bit early tonight. Wanted to make sure everything was up and running. You know, we've had some storms coming through these last few days. So I've been a little yikes. Wanted to make sure everything was up and running. So for tonight, but yes. There we go. I think we're good. I think we are. I've got a couple different screens, so hopefully I'm in frame okay for tonight, but we will see as time goes on. But happy Sunday. We made it, everybody. We made it to Sub Chat Sunday, where I have my chat turned on just for my subscribers, although everyone is welcome to join. This also gives a where I have my chat turned on just for my subscribers, although everyone is welcome to join. This also gives a me up tonight. 5 weeks of school, the final countdown. Good for you. Good for you. Oh, that's exciting. Summer break is coming. Yay. That's very exciting. I'm really looking forward to summer break this year. I have big plans. Big plans. Big plans this year. So we are, because my significant other or dual contract signer, I don't know what you want to call him, but is a teacher. He's a professor. So our summers can be really the only time he gets to really have a break. So I'm very excited about this break for this year. We needed it. We were ready for a break this particular year. So welcome in. Oh, Greece. Oh my gosh, that's so exciting. Wow. Oh, I've heard it's absolutely beautiful there. I have never made it that far out. I've always wanted to though, but oh my gosh, that would just be amazing. A beautiful place. So much history too. So, oh, that's exciting. Oh, I'm so excited for you. Very good. Oh my gosh. Yes, I mean, the closest I think I'll ever get to Greece well, I don't know. Well, you never know. You just never know. If you want to make it happen, you can make it happen. But that's definitely an amazing place to go. So I'm also really looking forward to the Olympics this summer. Oh my gosh, everybody. What do you think about the Olympics in Paris? I'm not sure how I feel yet. I'm not sure yet. Don't get me wrong. Paris is lovely. I enjoy Paris just as much as the next gal. But I'm not sure I'd want to be tooling around in Paris during the Olympics. That would not be my primary time for visiting Paris. I would prefer to go in the off. I always thought spring was hard, but I think during during the Olympics would be rough. Yes. Yeah, too much traffic. The traffic in Paris, yikes. Oh my goodness. Yes, messy indeed. Great if you don't look down. Oh my gosh, that's so perfectly put, Suze. Just don't look down and you're good to go for so many things in Paris. So very many things. Oh my goodness, odd venue. Yeah, well, we had London not too long ago. We've had Tokyo. I always get the winter and the summer ones mixed up. I apologize. Sorry for that. But yeah, it's been a while, I think, since it's actually, because we had Greece the last time, didn't we? I think Greece was the last summer one. Really? Gosh, it's been so long. Feels like forever. Just went to Paris. Oh, it's super crowded. Super crowded. But, everyone's just throwing bows in Paris. I remember walking down the Champs-Elysees and just being like, oh, I'm in Paris. And, look at that. I'm on the Champs-Elysees. And then next minute you're like, oof. So you get an elbow. You're like, whoops, sorry, my fault. So you got to be careful. I had an umbrella with me after that, just kind of cleared a path in front of me. That I found worked. That worked out well. Yes, Los Angeles. Oh my gosh. Oh my goodness. Yes, that's going to be really, traffic again. Oh my gosh. Oh, hello, John. Oh my gosh, that is fantastic. Oh my gosh, my goodness gracious. Most of the touristy places in Paris will actually be closed. Well, I'm not sure that's a bad call though. I think that's going to be pretty, pretty busy place. So now we had, oh wait, was it, okay, wait, hold on, everybody. Wait, I'm forgetting Brazil. How could I forget Brazil? We had Brazil last time. I cannot believe that. Right, right. We were in Brazil last time, and now we're going to, wasn't it? Right? We're going to Brazil. Rio, right, right. How dare I forget? Brazil is gorgeous. Oh, the colors were amazing in Rio. Oh my gosh, yes. So I had a family member actually who was in the Olympics in Rio. So I should feel terrible that I forgot about Rio. Terrible. I'm so sorry to my relative that I forgot about. Well done, you. Yes, yes, indeed. So I'm very excited. Here, the Olympics do not help the local economy. Yeah, there's something to be said for that when big events like that come into town, and it's not going to necessarily help that local economy as much as a lot of people would think because it's such a huge event. It's just so publicized and so taken over by the country, by the state. Love the Olympics. I know. Hi, hello, hello. I'm wondering, here's a question, everybody. Again, I'm just kind of chit-chatting a little bit while everyone gets their notices to come in for tonight. But I'm wondering, have you, the one time where I feel like our country can kind of set aside, the bologna sandwiches is during a good old-fashioned Olympic sporting event where it's the USA versus someone else, not someone we don't like, but just someone, that's against us being number one. And there's just a good, clean, swimming around the pool situation. And you can just cheer for your country and you don't have to worry about anything else. You're just like, woohoo! And, the national anthem is up and everything's good to go. I've always appreciated that. So that's one thing I truly, truly look forward to in the Olympics. And, as much as I love the beauty of the Winter Olympics, the sheer gold quantity of the Summer Olympics it has to be one of my favorites for sure. I shouldn't put it that way, but after all. Okay, Tokyo. Oh my gosh. Yeah, Tokyo was beautiful. Oh, I know. The Summer Olympics. I know. They're just for some reason, I mean, again, don't get me wrong, the pageantry and the sportsmanship and difficulty, athleticism of the Winter Olympics shouldn't be downplayed, but there's just something about the Summer Olympics. So, yeah, put the pitchforks down. Well, and even if you don't put them down, just put them to the side maybe, or just, douse the fire. just lower them a little bit for a little while. Oh my gosh. Brisbane, Australia. Is it back in Australia again? Oh my gosh. Wow. It seems like just yesterday I was in Australia. But, perfect place for that. So, the winter games are better. Well, and I understand. I tell you what. There are some winter game sports that I couldn't sleep because I was so nervous about what was going to happen. So I get it. They're just two different worlds. Like crunchy peanut butter or smooth peanut butter. Both are amazing peanut butters, but you've got your preference. Well, welcome in everybody. Welcome. I know there's some amazing different sports. So overall, it's always fun. But they're all peanut butter, everyone. So you gotta celebrate that. Well, welcome in, everybody. So tonight on my special sub chat Sunday, I have my chat just set to my subscribers. As a big thank you to my subscribers who help so much because we have so many pages of transcripts that my donor fund. Yikes. But I'm so thankful. The rest of the week, I do have my chat turned on to everyone, of course, but Sunday is just kind of my special sub chat. But I do like to make sure everyone can still come and hang out with us. So also, it's kind of nice to give my moderators a break. They do work very hard all week to try to keep some kind of control under the situation, such that we do. New here, well, welcome in. Good to see you. Good to see you. Jesse Owens in the 1936 Berlin. Oh my gosh, yes. Oh, I agree, Suze. I agree. I mean, there's just some, it's amazing. It's amazing. I'm excited for the Olympics, especially this year. It's been a while since I've been excited for, the country. So I'm really looking forward to it this year. So tonight, everybody, I've got kind of a blended plan. So since the chats to my subscribers, I thought I would do this just a little bit different tonight. Hello Hitch, welcome. I am planning to read through. Now, I've read through the transcripts in the New York criminal case. I've read through the opening statements. I've read through the gag order hearing or contempt challenge hearing. We read through that as well, but I've not done Mr. Pecker's testimony. So Mr. Pecker has been testifying for a couple of days, so I've got quite a bit of his testimony, and it's pretty good testimony, I think. So I do want to read through some of his testimony, but because this is my Sub-Chat Sunday, I want to kind of take it a little further than just reading. I do want to read big pieces of this because I think it's really important, but I could not even help myself when I was reading through this transcript, everybody. There are some huge objections that were brought up during the testimony. And I thought it would be really fun because of the level that the subscribers are at here. I know you all can follow me down this rabbit hole. I thought we would spend a little bit of time just going through the actual objection arguments between defense counsel and the New York DA as well as the judge, because there are a few pretty big objections going on in here and some of the rules that are involved. So I thought, let's kind of break those apart a little bit. I know when you hear it on TV, when you hear it, wherever you hear it, does anyone watch on TV anymore? I don't even know. But when you hear it out there, we're hearing different snippets from the transcripts, and those are great. But I'm not sure they've really gone through some of these objections. And there's a set of hearsay objections regarding Steve Bannon that I think are just fascinating. So we'll kind of do a bit of a mashup. We will do some transcripts reading, and then once we get to the objections, we'll kind of just switch it to kind of like a law school evidence class. So it's not legal advice. It will be just like you would be getting if you were in a law school setting, only, without the Socratic method and fear and loans. But we'll go through the rules just like we need to because they're really big objections. So we'll kind of switch a little bit over to law school style halfway through. So we'll do half and half with that. Sounds good. Okay, great. And then you can kind of take away from it whatever. This will be a great time just to ask all of those questions that you want to ask. And no question's a bad question. We can go through all of those things and kind of hash out some of the more technical legal questions that come up. Sometimes I try not to get too far into the technical pieces of the law because I feel like it's just too much. But I feel like for you all tonight, we'll be okay. About the loans portion. Yes, indeed. I would have too, Lisa. I'm with you on that. All right, so let's get started. Here. I've just got this picture just to give an introductory here. I will be showing the transcript because I've made some notes in the transcript, so you can just kind of screenshot if you're interested. But this is just to give you an idea of what we're kind of looking at here. We have Mr. Pecker over here. Now, as we all know, he is the National Enquirer dude who's involved in all of this. He and Mr. Trump had this deal worked out. And that's what the prosecutor's coming in to talk about is what was your deal about? How did it involve the 2016 election? Was there some interference involved, or not interference, but what's the word I'm looking for, everyone? Some illegal, I suppose, interference. Yeah, I think interference is okay. Some illegal goings-ons with regards to the 2016 election. So this is just to give you an idea again of who we'll be talking about. Oh, thank you so much, Estelle. Good to see you. Collusion's a great word. Yes, I hope you're feeling better, Estelle. Shenanigans is even better. One of my favorite words. Absolutely. So we will be just doing Mr. Pecker's testimony today. So it'll probably be a couple of times that I'll need to go through because he did testify quite a bit. So let's dive in and I'll take you to the point. Make sure, let me know if I'm in frame, everybody. Again, this is just the transcripts that were released. Very thankful to the New York courts for releasing these, allowing the public to have easy access to them. Transcripts can be kind of difficult to get your hands on unless you're within the community, and even then they can be incredibly expensive. So this is very really, really kind of them for us to be able to have these. Before, just to give you the background here of where we've been and where we're going, we did have that hearing regarding the contempt issues. We went through that. We had our opening statements also. So I'm going to flip us then through over to when we're getting our witness in. There's some housekeeping issues here that the court's going through as well, and then we have our witness that's called in. Now, I'm going to read chunks of his testimony, but again, I really want to kind of focus on what the legal issues were during the objections here. Welcome. Good evening, Desert Skies. Good to see you. Hello, VC. I will just be reading some portions of this. Now, as I go through this, I want to just show you real quick the exhibits that they're going to be talking about. The exhibits are available online as well for anyone who is interested. So when they're referring to the exhibits, I'll just show you these real quick. These are the different articles that were run through the National Enquirer, and some were to go after some of his opponents. Some of them were to make him look better. So they're going to go throughout his testimony and refer to this. So anytime you see exhibits, this is what he's going to be referring to. So I'll just show you these real quick. We've got May 12th of 2016, GOP unity after historic DC meeting, and May 25th, JFK's secret son endorses Trump. Oh my gosh, his secret son. Oh my goodness. Bombshell book exposes Hillary's lies and Donald Trump's path to victory. And then we've got some more negative pieces here. Melania Trump, how she inspired Donald to run for president. Secret weapon here. Trump's problem is what he said. Hillary's is what she did. So as you can see it just goes on and on and on all of these headlines here. Again, the goal in the scheme was to make the headlines so that his opponents looked awful and that he looked great. So that was really part of the scheme. I know these are really sad. These are really sad. Again, and then to promote his National Enquirer here. So these are all exhibits, again, that are available online that were shown. This one I thought was, some of these are just really, yikes. These are really, really bad, everybody. But we've got like conjoined twins. I mean, come on. My goodness gracious. This one I thought was interesting here. And this one, look at this, everybody. I mean, let me just cover that up a little bit. Just be a little careful. Look at this Ted Cruz situation here. Isn't that an interesting headline, I think? So this was a headline that they used to take down Ted Cruz. And, as compared to today. I know, right? I know. That's not so good. Again, and then we've got another one here. This one, again, I'm not sure how good that one is. Some of the words here, again, we've got more of this, which, are just the headlines these days. All right, I need to flip these a little quicker. Some of the words, yikes. I haven't redacted anything. All right, so the bottom line is these are these are all of the. I know he still supports. I know. So these are, again, the reason I'm showing you these is because these are the exhibits that the state's going to be referring to in some of the questioning from Mr. Pecker. So when they're saying state's exhibit blah blah blah, they're referring to one of these headlines in here. So. Just to show a little bit more here, we've got, just to show a little bit more here, we've got, And he was paid $30,000. So that's, and then we've also got some emails. So, don't forget the evidence is also available online. I know the transcripts are interesting, but the evidence itself is, of course, also very interesting. Well, thank you, Bruce. I appreciate that. Thank you. I have to make sure that when the puzzle piece comes up, though, that I'm very careful to move the piece because it's incredibly difficult to do anything with these nails on a screen. But Sunday is the perfect day for me. So, all right, everyone, let's dive in. Again, I'm going to be reading through pieces of this, and then we'll be stopping and going through some different rules. Now, tonight, if you see, I have made some notations in the margins as we go, so you can kind of make a note of that. A lot of the rules of evidence, of course, that I'm using just are only the federal rules of evidence. I'm not using the New York rules of evidence because they're so specific, and I think the federal rules of evidence give a better overall view for you to go look in your jurisdiction for your rule. Usually in New York, what they have is, a number and then point and then the same number as the federal rule, depending on which section of their evidentiary rules they're in. So I do have different rules of evidence, but again, they're federal rules of evidence that I've marked in the margins. So just kind of keep that in mind, and we'll be using those tonight to kind of go through and talk about how the rules work. So, and then I did bring my rules of evidence. This is the 2013 or 2023 edition. We do have a 2024 edition. I can't find mine, everybody. I know. It's because I take it with me everywhere. So my 2024 edition, I think, is in a vehicle that's not at my house right now. Whoops. So 2023, no big changes, so we should be fine. They come out every year, but it doesn't mean that there are major changes very often at all. So let's go ahead and dive in, everybody. Here we go. At the very top, we have the name of the witness and then what it is. We have a direct, and here is the attorney talking about that. So here we go. Court officer, witness entering. I won't be doing different voices tonight, everybody, just because I want to spend most of the time going through the rules, and it's just a back and forth between the state and Mr. Pecker. So I apologize for that. I kept trying to think, I was trying to work on a voice for Mr. Pecker, but they all seem to be kind of insulting New York, so I didn't want to do that. So you'll have to just bear with me, I apologize. But here we go, let's dive in. All right, so step this way, sir. Step to the officer. Okay. Welcome back, Mr. Pecker. I remind you, sir, that you are still under oath. Yes. You can get the jury, please. All rise, jury entering. Jury enters. I know, Woody the Woodpecker. Oh my gosh. Please be seated. The jury is present and properly seated. Good morning, jurors. Welcome back. Jurors, before we continue with the testimony of Mr. Pecker, I just wanted to clarify our schedule for the next week. And then he goes through and explains that, and I will skip ahead to that because I'd like to get into the direct examination. All right, so hopefully you can see the differences. According to my screens, you can. Blue, of course, is the government, and green is the witness as we go through. Good morning, Mr. Pecker. Good morning. When we broke yesterday, we were talking about Bonnie Fuller. And let me just ask you very briefly, during the period from 2015 to 2017, what was her title? Executive editor of Star Magazine. Are you also familiar with someone named Trish McAndrews? The name is familiar, but I don't recall. How about just Trish? Trish, yes, Trish was my assistant. So you don't remember your assistant's last name, Mr. Pecker? That's not going to go over very well. Well, I always called her Trish for a number of years, very rarely saw her last name. Okay, so during the period from 2015 to 2017, was she your assistant? Yes. Okay, are you personally familiar with Donald Jr. Trump? Yes. For how long have you known him? Since the 80s. Do you see him today in the courtroom? Yes, I do. Would you please point him out? Sorry, everybody. That was Donald J. Trump, not Jr. I was skipping ahead. I apologize. I apologize for that. Sorry. In case that came out incorrectly. We're going back through this here. Sorry. Hold on. I'm just making a note so we don't mess that up again. Donald J. Trump. So let me back up just a couple of lines, everyone. Now, again, the notations I'm making here on the side have to do with, as attorneys, there are certain requirements that we have to do for witnesses. Right now, the state's attorney is setting a foundation, what we call a foundation, introducing the personal knowledge this witness has of these different people, because the DA is going to be asking him about these different people. So he needs to establish that this witness knows these people. So we would call that foundational. All right. Okay. Are you personally familiar with Donald J. Trump? Yes. For how long have you known him? Since the late 80s. Do you see him today in the courtroom? Yes, I do. Would you please point him out, and would you please tell us something that he's wearing? He's sitting here. He is wearing, I think it's a dark blue suit. Now, something that a lot of people probably don't realize either, when we do this, one of the elements of every single crime that we have to prove is that the person that's actually on trial, the person in the courtroom, is actually the person that is the one who's been charged. So we always have some kind of identifying information. Can you tell me where he's seated right now? Can you tell me something he's wearing? Or can you tell me his exact location? And so that way it's in the record on appeal that the actual person in the courtroom that day is the true defendant. The court indicating Mr. Trump. Thank you, Judge. How did you meet the defendant? I met Mr. Trump at Mar-a-Lago. A client of mine, Ronald Perlman, introduced me to a fellow by the name of Nick Ribas. This is all at Mar-a-Lago. And he invited me to Mar-a-Lago, and he introduced me to Mr. Trump. And Nick was at the time, if I recollect, he was the president of Resorts Casinos, one of Mr. Trump's hotels and casinos. Again, anytime you see a rule over here, it's the federal rule of evidence I'm referring to, for those of you that's interesting, if that's interesting to you or not. And do you remember about when that was? I think I would say it would be in the late 80s, 88 or 89. At this point, just again, because this is a sub chat tonight and I'm tossing out what we would do if we were actually in court. For me, if he had answered 88 or 89, I would have asked him, well, do you know, sir, if it was before or after the Soviet Union collapsed? So I would actually ask for clarification. That's not necessary here for this person, but that's how you can clarify that. Was it before or after the Soviet Union collapsed or not? Can you describe your relationship with Mr. Trump over the years for the jury? Yes, I've had a great relationship with Mr. Trump over the years, starting in 89. I had an idea of creating a magazine called Trump Style, and I presented it to Mr. Trump. And he liked the idea a lot and just questioned me who was going to pay for it because magazines are pretty expensive. So I told him, I said, Mr. Trump, you have all of these hotels, all of these casinos, all of these apartments. You basically have a fixed distribution. So he liked the idea, and we went ahead and launched the magazine as on a quarterly basis. And I would see Mr. Trump probably once a quarter at that time to get the cover approved and then content approved. So did you, in fact, launch Trump Style magazine? Yes. Did your relationship with Mr. Trump change at all after you acquired the National Enquirer? Yes. Well, I should say that over the years, from 89 to when I acquired the National Enquirer in March of 99, over those 10 years, I was the president of a French publishing company. And I had a lot of dealings and discussions with Mr. Trump because as a celebrity in his own right at the time, he was very helpful in introducing me to other executives and other people in New York. And he would always advise me of parties or events or things that I could either go to or send at the time, or my editors to, and that was prior to the National Enquirer. And then when I bought the National Enquirer in March of 1999, one of the first calls that I received was from Mr. Trump. He called me and he says, congratulations. He says, you bought a great magazine. And he knew over the years, the editor-in-chief and a few of the editors of the National Enquirer. Now, are you familiar with the show The Apprentice? Yes. Can you very briefly describe that for the jury? Mr. Trump and Mark Burnett launched The Apprentice show on NBC. It was an instant success. And this was in 2000. I had a number of conversations with Mr. Trump about The Apprentice, what the ratings were and how it was doing. And he was always kind enough to send me the content, show the ratings, and I was able to publish that in the National Enquirer and some of the other magazines. And I received all that content. Obviously, I didn't have to pay for it. And it was a great mutual beneficial relationship because all of the press about the show and how it was doing was all published also along that time. Then in 2003 or 2004, when Mr. Trump launched The Celebrity Apprentice, then our relationship even started to grow even further because the celebrities that he was firing on the show and the amount of press that show received and the incredible ratings that it had and what I believed it did for Mr. Trump as a national figure on TV as the boss did a tremendous also help my magazines because the audience of the National Enquirer and the other celebrity magazines loved Mr. Trump as a major celebrity and followed him religiously, I would say. Then I would add on that a lot of the content on the show, whether somebody was going to be fired or terminated or there was some controversy he would have as the publisher, Mr. Trump was kind enough to give me the information first. So it was very beneficial for my magazine and then ran from 2004 into 2014. And then we've got a little bit more information about The Apprentice here. So I will fast forward a little bit. Let me make sure. Let me ask the chat. Chat, can you see each other's comments okay? I'm just noticing that is my paperwork pulled up enough for everybody? Let me just double check on that. Can you guys see everything okay? Should I move it a little bit more or are you good? Yes, you can see okay? Okay. Okay, excellent. Thank you. Okay, I think it's good. Thank you. All right, excellent. All right, so here we go. Let's get started again. So I'm just kind of going to skip through the longer pieces here. So here's the next question from the state here from New York. Now, you said that sometimes when you would call the office and you would speak to his assistant, can you give us her name? Yes, Ronna Graff. And is that his assistant at the Trump Organization? Yes, at the Trump Organization, Mr. Trump's assistant. Did you ever communicate with Mr. Trump through his bodyguard? Yes, I have. Do you remember his bodyguard's name? Keith Schiller. And was that something that you did frequently or infrequently? Infrequently. Did Mr. Trump ever call you from Mr. Schiller's phone? I believe I spoke to him on Mr. Schiller's phone maybe one time. Again, this is another thing where he has to introduce that he knows these different witnesses so that he can ask them about various things. Okay, and were there instances where Mr. Schiller would pass messages on to you from Mr. Trump? Yes, but also infrequently. Okay, did you have occasion over the years to observe Mr. Trump's business practices? Yes. In what context? I had a meeting with Mr. Trump in his office, and when I was there, his assistant Ronna brought a batch of invoices and checks to sign. And I observed Mr. Trump. He asked me while he was reviewing the accounts payable paychecks. We were talking at the same time, and I noticed that he reviewed the invoice and looked at the check, and then he was signing them. So on the occasions that you noticed that, could you tell whether the check was stapled to the invoice or just somehow attached to it? As I recollect, the entire package was stapled together. And so you observed him reviewing what looked like an invoice and signing what looked like a check? That is correct. How would you describe withdrawn? Did you visit Mr. Trump at Trump Tower on multiple occasions? All right, so hold on, everybody. I'm going to pause just for a minute. Yeah, it does seem like how would you remember from 10 years ago? But then on the other hand, if it's something that you regularly saw, I don't know. Something I do want to point out, at some point, we're going to switch over into cross-examination. And so when I've been talking a lot about direct exam versus cross-exam. Cross-examination is when you ask a leading question or a question that can only have a yes or no answer. A direct question means it's open-ended, so it invites a story. What we're noticing here is that a lot of the questions are yes or no questions. So here you can say, would he pass messages? Yes. And then what happened? Well, not necessarily and then what happened, but did you know about his business practices? Yes. And the answers are pretty short. But these questions, when he's asking more open-ended, like in what context, or let's see, down here further, it says, how would you describe, or did you visit? Those kinds of questions, that's what you're looking for on direct, because it really invites a huge answer. So those are those distinctions between a direct and a cross-examination. All right, so next up here, setting the stage. Yeah, I agree. All right, the next page here, we're going to get into Mr. Cohen. Over the years. Yes. How would you describe him as a businessman? Again, this is an open-ended question, a great direct question. I would describe Mr. Trump as very knowledgeable. I would describe him as very detail-oriented. I would describe him as almost as a micromanager from what I saw, and he looked at all the aspects of whatever the issue was. How about his approach to money? I thought that his approach to money, he was very cautious and very frugal. Are you familiar with someone named Michael Cohen? Yes, I am. Who is Michael Cohen? Michael Cohen was Donald Trump's personal attorney. Do you remember when and where you met Michael Cohen? I met Michael Cohen at a bar mitzvah in early 2000. And how did you meet him? Oh, one of the vendors of our company invited me and my wife to his son's bar mitzvah. And this fellow, he introduced me to Michael Cohen. Got it. Did there ever come a time when Mr. Trump also introduced you to Michael Cohen? Yes, I was in Mr. Trump's office and he introduced me to Michael Cohen. It was in 2007. And he said to me, and what he said to me was, he said that he hired Michael Cohen. He lives in one of his condominiums, that he has done a lot of great things for him, and all of the contacts that I had with Mr. Trump, that now my contacts should go through Michael Cohen. And anything that I came up and told Mr. Trump about, if there were any rumors in the marketplace about Mr. Trump or his family, or any negative stories that were coming out or anything like that, I heard overall, that I would call Michael Cohen directly. And that was back in 2007? Yes. So was that before or after the bar mitzvah where you had first seen Michael Cohen? Oh, 7 years after. And then they talked just a little bit more about this timing of when he met him. So I will fast forward just a little bit here. I don't know everything I signed. I agree, Name of Ed, I agree. All right, so during that period again, from 2015 to 2017, how frequently would you meet with Michael Cohen? I would speak to Michael Cohen probably if I had something to call him about, or I heard something. I had something to discuss, probably maybe once a month, twice a quarter. And then if there was an issue or something that he wanted to follow up on, or I advised him of something that we were working on, I would speak to him more frequently. After, I think you mentioned earlier that at some point we'll come back to that later, that at some point in 2015, you told us Mr. Trump announced his candidacy for president. That's correct. Did the frequency of your contact that you had with Michael Cohen increase, decrease, or stay the same after Mr. Trump announced his candidacy? Increased. So after the presidential announcement, how often would you say you had contact with Michael Cohen? I would say a minimum of every week, and if there was an issue, it could be daily. Do you know somebody named Hope Hicks? Yes, I do. Who is Hope Hicks? Hope Hicks was the communications director for Mr. Trump. I knew Hope Hicks also when she worked for Ivanka for her first for her fashion business. And then Hope Hicks worked for the communication company that I had at American Media the company was called Hiltzik Strategies. And Hope worked for them and his name was Matthew Hiltzik, and Hope was assigned to work for Star Magazine. Now, did there come a point after Mr. Trump announced his candidacy that Hope Hicks became the communications director of the campaign? Yes. Now, you mentioned in your previous answer the name Ivanka. For the record, are you referring to Ivanka Trump? I am, yes, Ivanka Trump, Mr. Trump's daughter. Correct. Thank you. I'm just making the record clear. Yes. So, directing your attention to early 2015, did you ever speak with the defendant about his interest in running for president? Yes, I did. And can you tell the jury a little bit about that? Yes. As I mentioned a little earlier, when Mr. Trump launched The Apprentice and then launched The Celebrity Apprentice, the interest in Mr. Trump through my magazines, basically the National Enquirer, skyrocketed. We would do a lot of research to determine what the proper cover of the magazine to be, to see which celebrity would sell the best. And in all that time, that every time we did this, Mr. Trump would be the top celebrity. So, and some of the other pieces of the research was clear that Mr. Trump was viewed as the boss. Seeing him in the boardroom, seeing him on each of the shows every week, he was the person. So I discussed with him that we did a poll in the National Enquirer about Mr. Trump running for president. Would he be, how would the readership feel? And the research showed that 80% of the readership of the National Enquirer would want Mr. Trump to run for president. And I passed the information on to Donald Trump. And shortly after he was being interviewed for the Today Show, and Matt Lauer interviewed him with respect to his aspirations for running for president. And one of the comments was about that that this poll that was just recently done at the National Enquirer. And then the next question says, so he cited your poll to Matt Lauer as he was flirting with the idea of running for president? Yes. And then we'll just skip forward a little bit. We have just the discussion of him being invited to the announcement of him running here. So I will just go forward a little bit. Again. All right, here we go. Now we're just skipping forward a little bit, everyone, to get the information in. All right, directing your attention to a couple of months later, so after the announcement was made, everyone. Now in August of 2015, is that right? Well, whatever, we're in August of 2015. Did there come a time when you attended a meeting in Trump Tower? So this is the key piece for the whole state's argument here. Yes. Do you remember when roughly that meeting was in August? It was in the middle of August. And who was present for that meeting? Donald Trump, Michael Cohen, and Hope Hicks. And was Hope Hicks there the whole time, or was she in and out? She was in and out. Now about Michael Cohen and Donald Trump. Were they there for the duration of the meeting? Yes. How did the meeting come about? How did you know to go? I received a call from Michael Cohen telling me that the boss wanted to see me. And that's how, when I spoke to Michael Cohen, that's how he would refer to Donald Trump, as the boss. What did you understand the purpose of that meeting to be before you actually got there? Most of the time when I received a call from Michael Cohen, he wanted something. So I assumed that they were going to I was going to be asked for something. I didn't know what it was before I got there. Well, can you describe for the jury what happened at that meeting, please? At the meeting, Donald Trump and Michael, they asked me what can I do and what can my magazine and what my magazine could do to help the campaign. So thinking about it, as I did previously, I said what I would do is I would run or publish positive stories about Mr. Trump, and I would publish negative stories about his opponents. And I said that I would also be the eyes and ears because I know that the Trump organization had a very small staff. And then I said that anything that I could hear in the marketplace, if I hear anything negative about yourself or if I hear anything about women selling stories, I would notify Michael Cohen, as I did over the last several years. I would notify Michael Cohen, and then he would be able to have them kill in another magazine or have them not be published, or somebody would have to purchase them. Purchase the negative stories about Mr. Trump so that they would not get published, you mean? That they would not get published, yes. So I want to break that down a little bit. First of all, when you offered withdrawn, so you offered to publish positive stories about Mr. Trump, yes. To publish negative stories about his opponents, yes. And to alert him through Michael Cohen when you came across damaging information, particularly regarding women, yes. And the idea that I would have objected to leading, by the way, during here, but whatever. And the idea was that so Mr. Trump and Mr. Cohen could prevent that information from being publicized? Yes. So you mentioned women in particular. What made you, are you the one that raised that? Did somebody else raise that? Can you explain to the jury how the topic of women in particular came up? Well, in a presidential campaign, I was the person that thought that there would be a lot of women come out to try to sell their stories because Mr. Trump was well known as the most eligible bachelor and dated the most beautiful women. Sorry, everybody, I need a tea break. Tea break. Okay, here we go. Whew. Back into it. And it was clear that based on my past experience that when someone's running for a public office like this, it is very common for these women to call up a magazine like the National Enquirer to try to sell their stories. Or, well, thank you very much, Kristen. Or I would hear it in the marketplace through other sources that stories are being marketed. Did you have or express any ideas about how you may be able to help kind of deal with those stories by women? All I said was I would notify Michael Cohen. What about Bill and Hillary Clinton? Did their names come up during this meeting? Yes. Can you explain how? As I mentioned earlier, my having the National Enquirer, which is a weekly magazine, and you focus on the cover of the magazine and who and what is the story, that is the topic of the week. The Hillary running for president and Bill Clinton's womanizing was the biggest, one of the biggest sales I had for the National Enquirer and the other tabloids. That's the other thing that the readers wanted to read about, and that's what I would sell weekly. So I was running the Hillary Clinton stories. I was running Hillary was an enabler for Bill Clinton with respect to all of the womanizing. And it was easy for me to say that I'm going to continue running those types of stories for the National Enquirer. And did you believe that that would help Mr. Trump's campaign? I think it was a mutual benefit. It would help his campaign. It would also help me. Okay, I'm going to come back to that and ask you to elaborate a little bit more. Okay, but specifically for the coverage of Hillary Clinton as an enabler of Bill Clinton's womanizing, that was your focus? Yes, that's what I said. How, if at all, did Mr. Trump react to your suggestion that you would continue to do that? He was pleased. Did you discuss it at any greater length? As I recollect, he was pleased. Michael Cohen was pleased on the way I was going to handle the issues, and that was the basis of the conversation. Okay, so now you started to allude to earlier that to some extent this arrangement that you came to at this Trump Tower meeting was mutually beneficial. Yes, that's correct. Can you explain to the jury what you mean by that? When I'm saying mutually beneficial is in a writing positive stories about Mr. Trump and covering the election and writing negative stories about his opponents is only going to increase the newsstand sales of the National Enquirer and the other tabloids. So for me, that was my benefit. And then in publishing these types of stories was going to benefit his campaign. So that's where I was saying that we were both parties were benefiting from it. And then our stenographer here is being switched, so to the next page. Again, continuing on with a direct examination of Mr. Pecker. And so, by each of the things that you agreed to do, did you believe you were doing both helping Mr. Trump's campaign and also helping sell some magazines? Yes, I needed the help. So, the portion of the agreement that involved notifying Michael Cohen about negative stories, either from women or some other kind of negative story, was what was the ultimate objective of that component of the arrangement that you made at Trump Tower? Can you rephrase the question? Yes, it wasn't a good question. I will try again. You said that the part of the arrangement was that you would notify Trump through Michael Cohen if you came upon a negative story, whether they involved women or just other negative stories. Yes. And what was the purpose of notifying Michael Cohen when you came upon stories like this? Well, as I did in the past, that would be in the past 8 years. When I notified Michael Cohen of a story that was a negative story, he would try to vet it himself and see if the story was true or not. He would go to the individual publication to get the story to make sure the story wasn't published and getting killed. Prior to the August 2015 meeting, had you ever purchased a story to not print it about Mr. Trump? No. Now, that part of the deal where you were going to notify them so that they could buy up a negative information about Mr. Trump, did that part help the National Enquirer at all? How was that going to boost sales of the National Enquirer? No, that didn't help. That is the mutual benefit portion of it. Except that part doesn't have a mutual benefit. The purpose of that component was to benefit the campaign. Am I understanding you right? That's right. But the part about running the positive story, that was mutually beneficial. Yes, the part about running the tabloid stories on the opponent, that was mutually beneficial. Were any of the agreements, the agreement to print the negative stories about the opponents, positive stories from Trump, or the agreement to notify Michael Cohen about potentially negative stories about Donald Trump, were any of those agreements put into writing? No. They weren't put into writing. It was just an agreement among friends. Roughly, how long would you say this meeting lasted? 20 to 25 minutes. Did you discuss this meeting with anyone afterwards? Yes. I went back to my office. As a matter of fact, I went immediately back to my office and I met with Dylan Howard. I mentioned his name yesterday. He was the chief content officer of the company and the editor-in-chief of the National Enquirer. I described to him the meeting I just had with Mr. Trump and Michael Cohen, and I described to him that this concept and agreement that I made has to be highly, highly confidential. So what I asked him to do was, I asked him to notify the West Coast bureau chief at the National Enquirer. His name was Jerry George. And I asked him to notify the East Coast bureau chief at the National Enquirer. His name was Barry Levine. And I said that any stories that were out there that are commenting about Donald Trump, commenting about his family, commenting about the election, whatever it may be, I want you to vet the stories and I want you to bring them to me. That's the whole country, all right? And then I said, we'll have to speak to Michael Cohen. You will call Michael Cohen or I will call him and we'll tell him what the stories are. But I want to make sure we vet them first. Did you tell him why you asked him to keep this arrangement secret? Yes, I did. What did you tell him? I told him that we're going to try to help the campaign, and to do that, I wanted to keep this as quiet as possible. Because if it came out that you were helping the campaign, it would kind of undermine the whole point. Objection, sustained. So let me rephrase that. Why was it important to you that the arrangement be kept secret? We have several hundred people that work within the company, and being a tabloid company, the leaks are probably most prevalent within the organization than outside the organization. And I did not want anyone else to know about this agreement. I had and what I wanted to do, so that's why I wanted it to be very confidential. So did you follow through? Did you publish a series of pro-Trump articles in the National Enquirer? Yes. I'm going to show you, and only you, well, the attorneys, People's Exhibit 153. And now us, everybody. Now we've seen it too. Tell me when you see that pop up on your screen. Do you see it? No, not yet. Yes, I have it in front of me. Do you recognize the document 152? Yes. What is it? These are articles and covers from the National Enquirer. Is it a document containing several headlines? Yes. for stories about then candidate Donald Trump that were published in the National Enquirer between August of 2015 meeting and around the time of the presidential election in 2016? Yes, that's correct. Do the headlines correspond to actual stories run in the National Enquirer during that time period? Yes, they are. And are the dates on the headlines accurate? Yes. And just to be clear, the exhibit is a collection of headlines, not the story itself. Yes, I offer them into evidence. And these are the pieces of evidence that I did show you at the beginning of tonight's live here. They are available online if you want to look them up. They are available through the New York court system. They have it on their Trump website piece. So you can click on the Trump criminal trial and then go in and click on evidence, which is next to the transcripts. Mr. Boyle is, anything in orange, of course, is the defendant. So we've got the state offering them into evidence. Then defense is saying, we have no objection. We ask for a limiting instruction. Jurors, the court is accepting Peoples 152 into evidence. The exhibit is being admitted for the limited purpose of demonstrating that the articles were published and the headlines were published and the dates they were published. Also, to put them into context, to put the rest of the presentation into context, the exhibit is not in evidence for any other purpose. This is making a record for any kind of evidentiary rule issued later. Thank you. Whereupon People's Exhibit 152 is received into evidence. Okay, now may we please display that to everyone? Whereupon an exhibit was shown on the screen. People's Exhibit 152. This is a series of headlines praising Mr. Trump. That was a question. Pardon me? That's okay. The question was, are these a series of article headlines praising Mr. Trump? Yes, I was just reading them. Did each of these headlines correspond to stories that you ran in the National Enquirer? Yes. And running these stories in the National Enquirer, was that a fulfillment of the arrangement that you struck or part of the arrangement that you struck at Trump Tower meeting in August of 2015? Yes. All right. You also mentioned that another component of that arrangement with Donald Trump and Michael Cohen involved publishing negative stories about Trump's opponents. Is that fair to say? That's correct. If we can go back to just showing the witness and the attorneys and the court, I'm going to show you People's 153A, B, and C. Do you see those? Yes. By the way, Mr. Pecker, have you had a chance to review each of these exhibits prior to today? You are not seeing them for the first time? Yes, I did. What are these exhibits, 153A, B, and C, in most general terms? These are negative articles and cover headlines or images that we published on Mr. Trump's opponents. I would like to say one other thing if I can. Sure. My conversations with Michael Cohen would call me and he would say, we would like for you to run a negative article on, let's say, for argument's sake, on Ted Cruz. Then he would send me, he being Michael Cohen, would send me information about Ted Cruz or about Ben Carson or about Marco Rubio. That was the basis of our story, and then we would embellish it from there. We, meaning the National Enquirer. The National Enquirer. I would speak to Dylan. He would hear the story. They would start putting together pieces of it, the photos, what makes sense, how we would try to do it, how the editorial would be executed. It was a process we were trying to explain, not just coming up with the headlines. Thank you for clarifying that. Let me just ask you, as part of your answer just now, you said Michael Cohen would call you periodically and say, we would like you to run a negative story about this political opponent or that political opponent. Is that correct? Yes. Who did you understand we to be referring to? Michael Cohen always told me he was not part of the campaign. So I only assumed he was talking to Mr. Trump. To or about? When I say we, right. Michael Cohen wasn't part of the campaign. When he said we, I thought he was talking about himself and Mr. Trump. Now, what did you understand Michael Cohen's relationship to the campaign to be? He always told me he was not part of the campaign. He did not work for the campaign. He told me he wasn't part of the campaign. He didn't work for the campaign. He was on the outside. He kept on saying he was Mr. Trump's personal attorney and that he is a lawyer and didn't have any issues. He said there was no issues with him with the campaign. And what did you understand, if anything, his relationship to the campaign to be? I don't mean formal. Let me put it to you this way. Did you understand there to be an informal relationship between Mr. Cohen and the campaign? Objection, sustained. When did you understand the relationship? What did you understand the relationship to be between Mr. Cohen and the campaign? Objection, sustained, overruled. Sorry, everybody. Let's go back. What did you understand the relationship to be between Mr. Cohen and the campaign? Objection, overruled. We have a sustained and we have an overruled. You can answer. What did you understand the relationship between Michael Cohen and the campaign to be? I thought that I'm going to say it the best way I can. Michael was physically there in every aspect of whatever the campaign was working on, at least at the Trump organization at the Trump Tower. He was physically there where the offices were. I thought probably he would have heard things. He wasn't part of the campaign, but I think he would have heard things informally, or he injected himself into it. And he said it was informal. That's what I thought, because he said he wasn't part of the campaign. When you say he injected himself into it, what do you mean? If there were an issue, for example, let's go back to Ted Cruz as an example. So he is physically in that environment, and if he heard, I don't know if he heard it from Mr. Trump or if he heard it from another person within the campaign or someone else, that there are issues about Ted Cruz, and we want this negative article to be written. I would only work with Michael, so I don't know who else spoke to. That's what I'm trying to say. Okay, when you use the phrase interject himself into it, is it the campaign? Yes. So back to Exhibits 153A, B, and C. My question is, do these documents contain different headlines for stories about various opponents that Trump was facing in various primaries that were published in the National Enquirer in the months following your August 2015 meeting with Mr. Trump and Michael Cohen? That's correct. And do the headlines correspond to actual stories run in the National Enquirer during that time period? Yes. And are the dates contained under each of those headlines accurate? Yes, they are. I offer them into evidence. No objection, subject to the same limiting instruction. People's Exhibits 153A, B, and C are accepted into evidence with the same caveat. This time they're being admitted for the limited purpose of demonstrating that the articles were published on or about a certain date and provide context for other exhibits. The exhibit is not an evidence for the truth of the matter asserted. Now, the judge has to say that in order to keep it out of the hearsay realm, which unfortunately it still gets into here in a minute. So, yikes! Whereupon the exhibits were received into evidence. Okay, I would like to show everyone People's Exhibit 153A. To which candidate does 153A pertain? Dr. Ben Carson. Were these articles published towards the end of 2015? Yes. Had Ben Carson been gaining popularity in the polls at that time? Yes, he had. And were these headlines run in accordance with your agreement that you had struck at Trump Tower in August of 2015 with Mr. Trump and Michael Cohen? Yes. I'm going to show you 153B and ask you, to whom does this series of headlines pertain? Ted Cruz. I'm going to show you a few in particular. I'm displaying the first exhibit, page 1. Does that headline say Ted Cruz shamed by porn star? That's correct. And did you run an article with that headline in the National Enquirer? Yes. Is there any story behind that one? I would like to clarify, just so that it's clear, that when we were preparing an article, let's say for Ted Cruz, we communicated what we were doing and the direction of the article with Michael Cohen. We would also send him the PDFs of the stories before it was published so that he could see what direction they were going, that we were moving to, and that he would comment on them. So he would add content based on the information, some of the information that Michael Cohen had. Oh my gosh, I'm pausing everybody. So Michael Cohen then pre-approved the stories of his opponents. Is everybody getting that? Oh my gosh. So he pre-approved the stories and even added bits to the stories that went into the National Enquirer. That's pretty hands-on. That seems hands-on to me. Oh my goodness gracious. All right. Did he ever tell you whether he had shared these headlines with the boss prior to their publication? I don't recollect that, no. Now, did there come a time when then candidate Trump introduced you to Stephen Bannon? Yes. I'm getting ahead of myself a little bit. I want to show you one or more of these headlines. Can we show them to the jury and the witness? Thank you. Scroll down to page 3, first headlines. Do you remember anything about the history of this article? In particular, this headline that states, Ted Cruz, this kind of scandal. I'm not going to say that word. Yikes. 5 secret mistresses. I don't remember the details of it, but I remember the article. Do you remember discussing it with Michael Cohen prior to its publication? We would have discussed it, yes. I'm going to show you one more from exhibit, which is exhibit 153B, page 5, top headline, Donald Trump blasts Ted Cruz's dad for photo with JFK assassin. Do you remember anything about the history behind this article? Yes, Dylan Howard had the research department take a look at Ted Cruz's father's photos, and we matched the photos in every different picture with that of Lee Harvey Oswald, and we matched the two together. That's how the story was prepared and created, I should say. Whoa, oh my gosh. I need a minute. I need a tea break to digest that. So he just pulled up photos of Lee Harvey Oswald and photos of Cruz's father, matched the photos, and built the story from that. Wow. Okay. All right, here we go. I mean, I don't know. Is that old school photoshopping? Is that what's going on here? Oh my goodness gracious. All right, here we go. And these articles that pertain to Ted Cruz, are they mostly around the spring of 2016? May I see that? Yes. I'm talking about the whole bunch of them. If you want, we can flip through them just to make sure you're comfortable answering that. Yes. So the question is, are these articles mostly around the spring? Mostly around the spring of 2016? Yes. Had Ted Cruz been gaining popularity as a candidate at that time? I believe so. Finally, I'm going to show you 153C and ask you, to whom do these headlines pertain? Marco Rubio. And were these articles published towards the end of 2015, beginning of 2016? Yes, they were. And had Marco Rubio been gaining popularity at that time? I believe he was. Do you remember when he dropped out of the race? No, I don't. Why were you running these stories about Marco Rubio and Ted Cruz and Ben Carson? After the Republican debates, and based on the success of some of the other candidates, I would receive a call from Michael Cohen, and he would direct me and direct Dylan Howard on which candidate and which direction we should go. That's how the process happened. Now, I started to ask you before, did there come a time when then candidate Trump introduced you to Stephen Bannon? Yes, he did. Do you remember around when that was? It was October of 2016. Who was Stephen Bannon at the time? Stephen Bannon was a political consultant for Donald Trump. And was he working on Donald Trump's campaign? Yes, it was my understanding he was working on the campaign. What, if anything, did Mr. Trump tell you about Stephen Bannon? He said to me that I believe that you and Stephen will get along really well. And Bannon, when I spoke to him, he said that he went through some of these articles that you just displayed now. He liked them very much. He had some other ideas, and would I be able to get him some other issues of National Enquirer he could take a look at? So in that meeting, I boxed up a bunch of issues of the National Enquirer that had Hillary and stories along those lines, and I remember sending it to his apartment. It was someplace on the Upper West Side. His apartment being Stephen Bannon's apartment. Did Donald Trump tell you specifically what, or even generally what, he wanted you to do vis-a-vis Stephen Bannon? He said that he thought that both of us could work very well together. And then, after Bannon reviewed the article, he called me and he said that objection sustained. When you are starting to answer, don't say what he said or what he or she was going to say. So now we're starting to get into this hearsay issue, everyone. And what you'll find is that the defense fights so hard to not get this information out on Stephen Bannon. It's really interesting how this really kind of takes a turn when it comes to Bannon. So there's a lot of information involving Bannon that's being protected here. So we'll start to go down that road here. So just kind of watch for that. The he was Stephen Bannon. What did you do after it withdrawn? Did Mr. Bannon ever pitch any articles to the National Enquirer? Objection. Overruled. You can answer. What he suggested was, based on some of the Hillary articles that we had, that we should take a National Enquirer reporter and have them go on the Hannity show and discuss the articles with Hannity. Articles that you had written. Objection. Move to strike. Sustained. That answer is stricken. So I'm not asking you about the articles. What you'll see continuing on forward, everyone. Again, I'm going to walk you through this portion of this because we've got... my battery is okay. My battery should be okay. I had a couple pieces in there. We should be okay. So what's happening is that the DA is trying to frame his question in a way to get around the defense's objections. So he's trying to get this information about what Bannon had told them to publish about Hillary, is what the implication is here. And he's trying to get that information into the record, but the judge they're struggling. They're going back and forth here. So let's take a peek. So it's going to really be get pretty intense here, back and forth with the legal arguments. So I'm not asking you about the articles that you did run or you had already run. Did Stephen Bannon ever ask you to run any particular articles? Objection. May I be heard at sidebar? Sure. Whereupon proceedings were held at sidebar. Thank you for hearing me, Judge. This is entirely hearsay. I understand that the witness at times is going beyond what Mr. Steinglass is asking. I respect that. In terms of what the jury is hearing regarding admissible testimony, I don't think that there is much of any with respect to this topic on Mr. Bannon. Mr. Steinglass? First of all, none of the statements that were elicited are hearsay at all. They're not statements that are being offered for the truth of the matter asserted. These are people who are at the time the defendant's behest, who were working with the witness to either pump up the positive stories about Mr. Trump or pump negative stories about the opponents. That is part of the whole scheme here. These are almost like verbal acts. It's not for the truth of the matter being asserted. If a witness is asked, if Stephen Bannon asked the witness to run a particular story, so you're not offering the statement for the truth. Now I'm going to pause here, everybody. And the reason why they keep saying this, all right, let me show you. The reason why they keep saying you're not offering this for the truth is because for hearsay, let me just show you quick what the rule is. Under the rules of evidence, hearsay is a statement where the parties offering into evidence to prove the truth of the matter asserted in the statement. So this truth of the matter asserted language is how they're determining if it's hearsay. If it's hearsay, it's not allowed unless there is an exception. If it's not hearsay, it is allowed. So that's why we're getting into that. Wire fraud, yes, that'll be next month. Oh my gosh, just a few weeks away now is Mr. Bannon's trial. So just keep that in mind. Anytime you're hearing this phrase for the truth of the matter, it's not being asserted. They're saying it's not hearsay. It's for a different purpose, another purpose. And so it's not hearsay. I need to give the jury an instruction, says the court. Ms. Nicholas, so the defense again is saying, these stories, he's not offering these stories, but the fact that Stephen Bannon asked this of the witness for the truth. He wants to put into evidence that Stephen Bannon asked this to show that Stephen Bannon did, in fact, ask it. That's the definition of for the truth. That is pure hearsay, the stories. He is not putting the stories in. He is putting testimony about what Stephen Bannon did. So she, again, is fighting this and is saying, if we talk about what story Stephen Bannon wanted him to put in, that's hearsay. So she's continuing to fight this here. Oh, and then back to the state. I think there are several answers to that, but at least one of them is if there are multiple co-conspirators, this is going to come up soon anyway. if there are multiple co-conspirators who are conspiring to influence the election under the election law, that is part of the secondary crime, which we have to prove that there is a conspiracy to influence the election. So this seems to me to be at the heart of the admissible evidence in this case. So I think it's res gestae of the conspiracy. It's res gestae and conspirator statements and co-conspirator statements. So let me pause again to just explain what's happened. So here the state is saying, in order to show his case, in order to prove his case, he needs this background information on Bannon and what he said to Mr. Pecker, the stories that he was involved in with Mr. Pecker. He's saying that this is a key piece to show the sequence, to show how the crime came about. That's what he's referring to with res gestae, which is a fancy way of saying that. Now, typically in the past, res gestae, which is a legal Latin term, could be an exception to hearsay. So judges would be like, okay, it's res gestae, we'll allow it in, we'll allow. And some places still do, but it's not allowed in New York. And federally, res gestae is not going to get you around the hearsay rules. You have to use the rules to get around the rules. So he's arguing res gestae should let it come in, and the judge is going to smack him down in a minute here. So I'm going to follow. We're going to follow down the hole, everybody. All right. So here we go. So I think it's res gestae of the conspiracy. It's res gestae and co-conspirator statements. Res gestae doesn't overcome the hearsay exception. This is the first we're hearing from the government about Stephen Bannon being an alleged co-conspirator in connection with the so-called conspiracy to influence the election. The government just elicited testimony that he's a member of the campaign working to do, at best, based on the hearsay that's been elicited so far, normal, traditional campaign work that everybody does. This should not come in as co-conspirator statement. Now the court's coming in. I will excuse the jury. So now everybody, the jury's coming out of the room. So things are about to get heated. Things are about to get messy. So out goes the jury. All right, everybody ready? Whereupon the following proceedings were held in open court. We're going to go ahead and take a short break at this time. You can step out. The jury's leaving the courtroom. Mr. Pecker, you can step out as well. So out goes Mr. Pecker. So now here we go. Are we ready? We're ready for the fight. Here we go. So this is defense counsel. As I was saying at sidebar, we object to this line of inquiry because what's happening here is the government is eliciting hearsay statements from Stephen Bannon as declarant. Now, I'm going to pause us as we go through this to explain what all of this means, all right? They're being offered for their truth. So now hearsay, all right, again, and I'm not going to spend too much time explaining it, but hearsay has to be a statement. It has to be made by a declarant. It has to be made out of court. And it has to be made to prove the truth of the matter asserted. Those are the key elements to hearsay. If this is present, we have hearsay. That's it. So 1, 2, 3, 4. 4 elements to have hearsay. So what he's saying our declarant is Mr. Bannon. And they are being offered for the truth. So now we have 2 pieces of hearsay. And so he's saying that this is a hearsay statement. There's also has been no notice that the government considers Mr. Bannon to be a co-conspirator in this case. As the court knows, there's no conspiracy charged in the indictment. Statements by a campaign staff member doing normal campaign work do not further any alleged conspiracy that the people are relying on as a predicate act. So let me translate this. So conspiracy, as I've said before, and I apologize if I'm just repeating myself, but conspiracy is what we call an inchoate offense, and that means the primary goal or the crime itself that they're trying to commit doesn't have to be committed. It's the agreement to commit the crime that is the crime. That's what makes it an inchoate offense, right? We have solicitation, attempt, and conspiracy. So here we're saying in conspiracy that we have a predicate act, meaning a significant act or a substantial step towards completing the conspiracy. All right, so they're saying that he's trying to rely on these statements as that substantial step towards the conspiracy. That's what defense is arguing here. So much to take in. Oh, there really is. There really is. There really is a lot. So, okay, so again, this is what defense counsel is saying here. So, defense counsel is saying the state is trying to argue these statements that Bannon said are part of the conspiracy, but they were not given notice that the state had Bannon in a conspiracy. And they're saying that, that again would nullify this ability to use the conspiracy argument. Now, this again is just defense, and the state's going to come back with a really good argument in a minute. So, how many are needed to have a conspiracy? Two or more. Two or more people. You just have an agreement between two or more people. The sheer number doesn't matter. What's different, the difference between, and we've been talking about this a little bit too, the difference between a RICO and just a straight up conspiracy is that there's a criminal enterprise with a RICO. A criminal conspiracy is just two or more people agreeing to do some kind of a crime. All right, so that's the big difference. Is with a RICO we have an enterprise, a criminal enterprise, and with a conspiracy we just have a couple of people agreeing to conspire to commit a crime. All right, next up. So, and the limiting instruction that you are giving with respect to the newspaper articles could not adequately cure the risk of prejudice when we're talking about testimony from statements like this. So let me break this one down. The limiting instruction is for the jury. The judge has been coming in and clarifying as we go along, saying this evidence is only for this specific thing. That's a clarifying instruction or limiting instruction. They're saying here your instruction's not good enough to overcome the prejudicial issue. The prejudice is that 403 issue, right? Probative value versus prejudicial effect. So we have to balance those out. And he's saying that the instruction the judge is giving to the jury is not enough to cure that. And so because of that, again, it needs to get tossed. We can't go forward in this line of questioning. It's just very far afield from what the charges are in this case, what has been alleged before the line was elicited about how this conspiracy functioned. And so the reason I asked for the sidebar, it's difficult on a question by question basis, other than just continually, we think this whole line is inadmissible. So the defendants are making they're making a valid point. I cannot say that this is not a valid point. If they are trying to get the information Steve Bannon gave to Mr. Pecker about requesting certain kinds of articles about Hillary Clinton, is what it sounds like, I'm just making a presumption here, based off of what he's testified to already. So those requests and then what articles were actually published, that line of questioning, they're saying, is pulling Bannon in to this conspiracy issue, which they had no notice of, has not been charged, and they are saying it's inappropriate, so it needs to get tossed. All right, so the court is saying the people, so we're in New York, so rather than the state, the court's saying, what's your response to the people? So let's see what the state has to say in response, and I think they do a pretty good job, actually. Who wins? Well, we'll find out. But I think they both actually make good legal arguments here. So here's the people. So several things. First of all, part of what we will be eliciting here is what Stephen Bannon asked the witness to do. The question is not hearsay. It's not a statement that's being offered for the truth. It is, as I suggested at the bench, much more akin to a verbal act. So again, we're talking about this language offered being for the truth of the matter asserted. And I just have to tell you, everybody, when you're in trial and you have hearsay objections, you will always have a hearsay objection somewhere in there. And you will always be at the bench and you will be arguing this with opposing counsel. You just will be. I mean, which side you're on, it just depends on where you're at. But you will always have an argument like this where we will say, we're not offering this for the truth. We're offering it for something else. And the people that want to keep it out are like, this is for the truth. This is just fundamental basic evidence class right here where you have to fight these kinds of battles out. So moreover, and let me just say, I think that we've gotten enough on this topic. So the state is saying, you know what, I think we're actually going to move on here. So let's not stay here too long. So I don't really need to go back into it. This may be moot. I do see this coming up. Counsel said it yesterday in the opening, and Mr. Bove said it again. And I think there is misperception about the law and about what this case is about. So this is the moment where the state reminds defense counsel that this isn't just about hush money payments and false writings. This is about an effort, a group effort here to catch and kill these stories in order to win an election. And that's what I take the state saying here. They're saying here that the defense has a misconception about what this case is about. All right? It is true that there is no conspiracy charge on the indictment. However, as the court is aware, falsifying business records in the first degree requires an intent to defraud. That includes the intent to commit or conceal another crime. The primary crime that we've alleged is New York State Election Law, Section 17-152. There is conspiracy language in the statute. And so for me, this is like, well done state, or people, as they like to be called in New York. So the language sounds like a conspiracy because that's how it's written. So there doesn't need to be any notice. Why wouldn't they file a RICO? We don't have a criminal enterprise here. And I'm not really sure how the criminal RICO statute in New York would not turn this into a huge disaster, in my opinion. So sometimes a scalpel's better than a baseball bat, and in my opinion, if they want to come in and put a full RICO in for some hush money payments that we're not sure we're even going to get in this case, because 50-50 in front of a jury, then to pull a full RICO, can you imagine? I mean, just for a minute, I'm not saying that there isn't a legal basis. I don't know the ins and outs of the case, but can you imagine what it would have been like if the New York DA had charged a RICO case against Mr. Trump in this case, New York RICO case, off of these 34 counts of hush money payments? Can you imagine? It would be like, what? I think all of us would have just passed out. We're like, that's it, we're done. We're done with this. We can't even do it anymore. Yes, exactly. So, right. So why go after it if in a huge RICO mess, if you can pull in 34 felonies? So again, it's one of those, you got to kind of pace yourself. But valid question. So here's the language in the statute. Any two or more persons who conspire to promote or prevent the election of any person to a public office by unlawful means, and which conspiracy is acted upon by one or more of the parties thereto, shall be guilty of a conspiracy. So that is the specific code section here that they're proving. Misdemeanor. So while it's true that there is no conspiracy in the second degree charged on the indictment, it's not true that the conspiracy has not always been alleged to be part of this case. Now that is like a hard burn. So what the state is saying is that we know there was a conspiracy going on. We chose not to charge it. We chose not to go down the RICO road, down the conspiracy road. It doesn't mean it wasn't here. It just means we chose not to charge it. So I thought that was fantastic. This entire case is predicated on the idea that there was a conspiracy to influence the election in 2016. Mr. Bove may interpret some of the evidence in a way that's different from the way that we interpret it, but that's what the jury's role is, to interpret what the nature and scope of that conspiracy was. This is evidence that will aid them in making that determination. So that was, I know the shade, I know. So that was the big kaboom that the state dropped. And I thought they did an amazing job. So that was their comeback. So let's see what the court decides. So I agree. Here's the court next. So I agree with what you're saying, Mr. Steinglass. The state My concern is, did you give any notice that you intended to elicit this type of information and ask these types of questions from the witness about Mr. Bannon? No, I don't think that we did, although I'm not sure that there is a requirement that we do so. That being said, I think this issue will come up with other testimony more so, and we can stop asking questions about Stephen Bannon and his involvement in this conspiracy. Since we're talking about it now, so again, the state's saying, we can pull back on our questions here. We can pull back on our questions at this moment and deal with this later. So the court is saying, since we're talking about it now, I'm sorry, one more thing I will say. I don't mean to interrupt you. The state's going again. To finish my thought, Bannon's name is all over the exhibits and the discovery that we provided to counsel. So even though we never specifically say there is a view of the evidence that he could be considered a co-conspirator in this aspect of the conspiracy, it is not like it's the first time they're hearing his name. Yes. I think there's about 11 million pages of discovery, so the fact that somebody's name appeared in those pages, I'm not sure that puts anybody on notice that hearsay from that person as a declarant at this trial is going to be elicited. So this is like the most lawyer answer ever. I thought that was pretty good. Do I agree? I'm not going to say one way or the other, but I think it was a very good lawyer answer. There is no misrepresentation on this side about this predicate that Mr. Steinglass just talked about. I think what the issue is that the existence of a conspiracy argument is not the sole requirement for the hearsay exception we're talking about. So here he's talking again. He's saying they're trying again. Everyone, let me take a step back real quick. They're trying again to say, if you want to get around hearsay, you have to follow the rules of evidence. And so he's saying, the defense is saying here, not only are we talking about this conspiracy in general, but we're talking about this conspiracy as a way to get the hearsay statements in. Let me show you what I mean. So we go back to the hearsay rule here, everybody. Back into the hearsay rule. So here's hearsay. It's set out here. The hearsay rule. And under the hearsay rule, we have statements that are not hearsay. So if the rule says it's not hearsay, then it's not hearsay. And if we turn the page, if we look down into the rules under subsection 2, an opposing party statement, so any kind of an admission, here it says it was made by the party's co-conspirator during and in furtherance of the conspiracy. So this means statements made by co-conspirators in furtherance of a conspiracy, those statements are considered not hearsay because the rules say that they're not. All right, I know, mind blown, right? So if technically we're talking about a conspiracy situation, it's possible to get his statements in as a co-conspirator, but defense is saying, even if you tried to use that, we still don't have enough built up in order for you to say he's a co-conspirator in this case. Yeah, this would be incredibly detrimental to Bannon, right? Who's heard about Bannon with regards to all of this hush money stuff? This case has been about 34 documents. Michael Cohen, Stormy Daniels, and, now Mr. Pecker, right? So that's what this case has been about. This case hasn't been about Stephen Bannon coming in and talking to the National Enquirer. Who knew Stephen Bannon had the ear of the National Enquirer, right? I mean, this is kind of new information. Trouble digesting while reading. I know, right? I know. Well, right. So the intricacies here are a bit sloppy. They're a bit messy, but that's how our rules kind of work here. He just came up and right. The state, well, true. It seems that way, but the state is saying, I think that this is like one of those, for me, I appreciate like a good, honest fight in court, because I think this is really the state's coming in and saying, wow, we had no idea that you guys were going to object to this because it's not hearsay under how we're looking at it. Meanwhile, defense is saying, whoa, you're pulling in this conspiracy element. If you're going to pull it in, you need to plead it properly, and you didn't plead it properly. So the state's like, well, we're not pulling it in. It's always been there. We don't have to plead anything. It's just this good old-fashioned argument kind of back and forth legally. So just a good, clean argument, in my opinion, although sloppy. That doesn't make any sense. All right. You know what I'm saying. So here we go, back in. Let's jump back in. The statement that's being offered also has to further the conspiracy at issue. I don't think there's any basis for a conclusion that what was just elicited from Mr. Pecker regarding Mr. Bannon is furthering the conspiracy that is alleged as the predicate to charges in the indictment. What that was, I submit, is a very normal standard campaign work. And I agree with Mr. Steinglass that it's the type of thing that will come up throughout the trial. That predicate should not be used as an excuse to shovel in hearsay from witnesses who will testify at trial. So now I think that, in my opinion, defense is pushing it too far. Defense is taking this too far now. I think they see a toehold and they're going too far on it. So the court is saying, let me hear from Mr. Steinglass. So again, Judge Mershon is really going back and forth and looking at both sides to try to figure out what the best solution is. Mr. Steinglass, so we've got the state again. I think we disagree with the characterization to the extent that Mr. Bannon could be seen as a person who is contributing to the endeavor to publish negative stories about Mr. Trump's political opponents. That is very much a part of the conspiracy. True, that in and of itself might not be criminal. We can have much debate back and forth on this. In connection with all of the other evidence in the case and the robust component of the agreement that was forged at Trump Tower to influence the election, that was a piece of it. The evidence doesn't have to be conclusive to be admissible. It has to be relevant, and it's relevant to the idea of the conspiracy, whether Mr. Bove has proved innocent explanation for it or not. Which is an excellent argument. Absolutely valid. Prosecution was ready, Amber. Yeah, I think they were ready. I am so impressed by this prosecutor's comebacks from these objections. And I have to say, too, I mean, like this Mr. Bove's he's not too shabby either, quite frankly, when we're dealing with technical, evidentiary, legal questions. I think he's doing an okay job, but I think definitely the DA did a good job here. All right, the court is coming in and saying, all right, so here we go. Here's the court's decision then after that big argument. With regard to Mr. Bannon, at this point, it appears to be a moot point because you're going to move on, right? So we had this argument back and forth about Mr. Bannon. Is it hearsay? Is it not hearsay? Is he part of a conspiracy? Is he not? Are we going to talk about the conspiracy? Are we not? And the court's like, it's moot, move on. That I think summarizes law right there. This sentence just summarizes the entire legal world. Like, let's debate, let's go back and forth and figure out these complicated issues and then drop it. Genius. All right. And then the state's like, yes. All right. Here we go. Keep moving forward. This is something that we need to move on moving forward. I do agree with the people's assertions that they are required to prove that there was an intent to commit another crime. And in this case, the court has given the people permission to pursue 3 different theories of that, so long as the people can establish that the testimony that's being elicited does advance one of those 3 theories. I think it's fine. I think it's acceptable. And this was set out in one of his orders that he had done prior to trial. So that was already clarified in there, those 3 theories. We kind of went through that in another live. Mr. Bove, just so I understand, when you say advance, you mean the otherwise inadmissible hearsay at issue to further the predicate that we're talking about? And the court says it has to be viewed in context. The one statement that is made may not move the ball. But if that one statement in the context of everything else does, then it would be admissible. Let's take a brief recess. So the judge is saying we're going to have to look at the context depending on the situation, and that will depend on the questioning for how we're going to deal with it in the future. That arguments with your parents don't like the legal system. All right, here we go. Moving forward, everyone. So there we go. There was our first heated exchange, which, I thought was quite good, quite professional. Well done, team. So let me take a tea break quick, and then I'll dive into the next piece. All right, here we go. Back in. Court officer, witness is entering, whereupon the witness, David Pecker, has been previously duly sworn and or affirmed to resume the witness stand and testifies as follows. Back, Mr. Pecker is on the stand again. The court says, Mr. Steinglass, that's the people, thank you. Continued direct examination. During the time that you were the CEO of AMI, did you have access to the business records of AMI? Yes, I did. And did the business records of AMI include invoices, vouchers, general ledger entries, non-disclosure agreements, and amendments related to the subject matter of this case? Yes, they do. Do the records also indicate emails and texts back and forth between and among AMI employees, as well as business-related texts and emails between AMI employees and third parties? Yes, they do. Were those records, emails, and text kept and maintained on an AMI server, computer, and employee cell phone? Yes. I'm now going to hand you a thumb drive, whereupon a thumb drive is given to the witness by the court officer. What? I'm going to ask you to take a look at it and let us know if you have had an opportunity to review the documents contained on that thumb drive. Yes, I have. How do you know? I have my signature in the date that I looked at it. Have you had an opportunity to review each of the files contained on that thumb drive? Yes, I have. A moment ago, I asked if some of the exhibits on the thumb drive contained emails. Yes. Does AMI maintain a server that hosts its emails? Yes, they do. Does those servers capture information associated with to, from, date, time sent, and those kinds of things? Yes, they do. And is the information generally accurately contained in the header of each email? Yes. Now I will skip ahead a little bit, everybody. Here, what I'm trying to show you is how they're establishing the authenticity of the evidence. So we're going to see a lot of emails coming in, a lot of emails. And actually, I think it's still in my printer. I have just a huge list of the exhibits coming up, and they're almost all different texts and emails. So in order to establish those being authentic so that we don't have issues with getting those exhibits in, he has to establish where they came from. So that's what he's doing here. He's setting that authenticity issue up. So let's go forward a little bit here. Again, he's talking about the IT department, how exactly their system works, so that he can clarify how that information was stored. So when he wants to introduce those texts and emails, he has enough set up for that. All right, let's dive back in again. I offer in evidence people's exhibits, blah, 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 blah. Can you repeat that? Sure. 158 through 170, 154 through 170, 179, and then blah, 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 blah. So they go through the exhibits here. How we get called in as an absolutely VC, and we ask you, like, is this your standard operating procedure? How do you keep your stuff? What do you do to keep your stuff? So any objections? So he's trying to offer in. Let me just go back real quick. So he's got these exhibits he's trying to offer in here, and he's asking defense, do you have any objections? And defense is saying, yes, judge. What are the grounds for your objections? The hearsay objections that I raised yesterday, as well as the testimony that was just given about vouchers, come up, whereupon the following proceedings were held at a sidebar. So here we go. We've got another kind of debate coming in regarding the testimony that Mr. Pecker gave regarding this information on how the company stores and keeps different kinds of information. Thank you, Judge. So text message exhibits 1, and as I understand it, 171 through 179. That's what I have. With the cash pays, to the extent those text messages were originated by Mr. Pecker, we object on hearsay grounds I articulated yesterday, that even if they are business records, the statements in the text messages are being offered for the truth, and they are inadmissible hearsay on that basis. When Mr. Pecker is a communicant of the text message, I understand those can come in, and the person he's communicating with. The other side of those messages, there we go, can come in for context. There may be a subsequent point at this trial where other witnesses testify and make other of these text messages admissible. The fact that the text messages are business records, I agree the foundation has. Are those being offered for the truth? So again, we're getting back into this fundamental question. And the state's saying, yeah, I think they are. I think to the extent that I think there's two separate issues here. One is, are they business records? It sounds like the defense is not contesting that. Right. The second is, are there perhaps embedded hearsay in some of these, not admissible by other hearsay exception? So, hold on a minute. If you have hearsay, everyone says, oh, it's hearsay, it's not admissible. Not true, because we have things called not hearsay, which we just talked about. So if you make an admission, right, if a defendant is in jail and they write out a confession, technically that's a writing made outside of court being used in court to prove the truth of the matter asserted. But the rules say a confession written by a defendant is not hearsay, just because the rule says it is. Now, along with not hearsay, we have all the exceptions, all right? So I'm not going to get too technical. This is about as technical as we're going to get here. But when we go into hearsay, what you want to look for then is there an exception? And all of the exceptions are listed out in 83. We have 1, 2, 3, 4. I counted them up. It came out to around 27 or 28 total exceptions. You just keep flipping. Pages and pages and pages and pages. We have 804, which sets out another set if the declarant's not available. Hearsay within hearsay. Other kinds of hearsay residual exceptions. These are all hearsay exceptions, everybody. So when you say, oh, hearsay can't come in, that's not true, because it probably fits under one of the exceptions. I like that it's technical, it's helpful. Oh, good, I'm so glad. So the trick with well, not really a trick, but the key with hearsay, everyone, is that, and this would be on your law school final, take the notes, is that you have to find an exception. So what's being talked about here, we're talking about records of regularly conducted activity. Now, we call this the business record exception. Now, this is what they're going to be talking about. We have an exception here that's saying if there's a record was kept in the course of regularly conducted activity of a business, organization, occupation, or calling, making a record was a regular practice of the activity, all the conditions, blah, blah, blah. And so it was made at or near the time, or the information was transmitted by someone with the knowledge. So if you have a business record and you can fit it into that exception, then even if it is hearsay, it's still admissible. So that's what they're arguing about right here, everyone. That's what they're arguing about. So let's go back and say, okay, the court's saying, are they being offered for the truth? So he's asking, is this going to be hearsay? And the state is saying, yeah, I think they are, but defense just said, are they business records? The court said, right. The state just said, are there perhaps embedded hearsay in some of these, not admissible by another hearsay exception? So he's asking, he's like, is the business record exception not enough? Do we need another hearsay exception? And the court is saying, right. And the state is saying, we're all working hard here. I do feel like it's a little late in the game to be raising these objections. They've had these exhibits for 9 months, and they've been designated as exhibits since August of last year. But to the extent that there may be some embedded hearsay in some of those, I think that the defense needs to do is identify those portions of the exhibits that they believe is embedded hearsay. And then we can have argument as to whether or not there's a valid hearsay objection. But we've laid a foundation. They're admissible as business records. So that's what I was telling you about when he was asking those questions. Those kind of like boring questions of Mr. Pecker, like tell me about your server, how do you keep your stuff? That was that foundation I was telling you about. And he had to lay that in order to set it out as a business record to get it in under the hearsay exceptions. See how that works? Yeah, I know, right? To the extent, and the court comes in and says they're admissible as business records. There's no dispute with that. But if it's hearsay, it's still hearsay, and you still have to get it out. I don't think the solution now is to send the defense back to look through each one of these exhibits. If you know anyone you're offering contains hearsay, maybe you can make it easier for all of us. And the state laughs. Wahaha. Well, I don't mean to be laughing, Judge. I think the state may be losing their cool a little bit here at this point. There's a lot of exhibits here, and there's a lot of text back and forth. It's our position that primarily there's one thing that Mr. Bove said that I very much don't agree with. which is that there's some relevance to whether the declarant is present. All right, so this gets tricky again. Again, follow me to evidence class in law school, everybody. All right, follow me to evidence class. So if a declarant is present or not present, all right, follow along. Okay. So we have exceptions. Again, I'm using the federal rules. We have exceptions to hearsay that fall under 803, and that's when the declarant is present. We have exceptions to hearsay under 804. That's when the declarant is not present. So he's trying to say, wait a minute, are you saying we need to use a different evidentiary rule to figure out how to get this information in? So that's what he's referring to here when he's saying the declarant isn't present, because that leads us to a different rule that we have to use. All right, so here we go. So if the declarant's present, the declarant's present, then we're going to use 803. If the declarant is unavailable, right, we have other exceptions that we're going to use. So that's what he's getting into. Now, a business record is a business record if it's between two people, is what he's saying. The court says, we don't need to get bogged down with that. All I care about is there hearsay or isn't there hearsay, says the court. Oh, my goodness. All right. The reason I'm saying that two AMI employees having a text about a particular story, like the Dino Sujazin story, that is admissible hearsay. It doesn't matter if he's not here testifying. So this is why that whole issue came up. If he's not present to testify, because the state, all right, let me backing up. We're still in law school, everybody. Keep your law school moment with me in evidence class, all right? So the court is saying it doesn't matter if he's here, if he's not testifying in this particular situation. So this idea that the declarant is not present is not an issue here. So then back to the state, and they're saying, well, both of them. And the court's saying, right, it doesn't matter provided that they come in under some other exception. So the court is saying, if the declarant's not available, let's see if there's just another exception that it will fall under. And then the state is saying, okay, because it would still be hearsay even if it's a business record. And the state's saying, oh, well, okay. We don't need no fucking... Oh my goodness gracious, everybody. I know it's complicated, but I believe in you. Subscribers. I wouldn't be able to do this straight out in the open. That's why I was comfortable doing it with y'all tonight. So here we go. But I will say a couple of things. First, I think that the fact that it's a business record may mean that conversations amongst employees about business-related matters are admissible because they're business records, even if otherwise there would be no business record. So he's arguing this business record exception. Everything in a business record is arguably an out-of-court statement being offered for the truth. So that's what hearsay is. So I don't think that, for example, if a person who is a party to a conversation who is not under a business duty to do so accurately, that would be embedded hearsay. And that would need to find another exception to the hearsay rule. I believe the primary exception to the hearsay rule on which we would rely is co-conspirator hearsay. Now we're back. Had this since August. Now we're back to the co-conspirator hearsay issue. Remember, I told you about that before, right? If you make an admission, or if you're a co-conspirator and you're making admissions as a co-conspirator, that can still be used, even though technically it's hearsay. So that's not an exception because technically they don't call it an exception. They just call it co-conspirator hearsay because they're stupid, because they put stupid names on the rules. And I believe the testimony of Mr. Pecker has already established a prima facie case of conspiracy. So that statements made in the business records that are in furtherance of that conspiracy would be admissible in addition on those grounds. So let's back up a minute. So he's saying already the testimony of Mr. Pecker has established for the state on its face a good faith case for conspiracy. Mr. Pecker's evidence has already set out the elements needed for conspiracy. So because of that, because of that conspiracy element, he's saying here, in furtherance would be admissible in addition on those grounds. So we've got multiple grounds, business records and conspiracy. So there's multiple ways that this should be able to come in. But I think I'm suggesting gently, that's when the prosecutor's starting to get frustrated. I am suggesting gently that it would be an uncharitable view of the business records exception to suggest that every statement contained in a business record has to be independently admissible under some objection other than the business record. And I agree completely. This would be like interlocutory appeal worthy if that was true. But let's see what the judge says. Oh, the judge agrees. Yay! Oh, we got it. Okay, the judge agrees. Yay. All right, everybody. It's hard fought, but we got it. All right. The judge agrees. We're gently suggesting, and the judge says, okay, I agree. All right, so let's see what defense is saying. Let's see what they're going to come back with here. Judge, that's the law. That's where there's embedded hearsay within hearsay, and that there has to be another basis for the statement to be admissible. That's in the New York Rules of Evidence. It is not an exception to the hearsay rule that the communicants are each employees of the company, whose business records are being offered. The fact that the employees are on those records does not make them admissible. There's not been a foundation laid for suggestion, if I understood it correctly, that AMI, every name of an employee is charged with a conspiracy, is charged as a predicate. So we're all the way back to the beginning with that predicate or significant step act here. It is their burden to establish admissibility. So then the court is saying, I'm accepting the records into evidence as business records. So now we're done. The judge is done. If something comes up that you believe is hearsay and it's not admissible, you can make an objection. Just, can I lay out the numbers? Yes. Oh my gosh. I don't know why this cracks me up, but this judge is just like, tell me one side, tell me the other side. I'll make a decision. All right, now we're done. We need to move on. I just love that about this judge. All right, here's defense again. 173, 174 text messages between Mr. Pecker and Dylan Howard. So we're not objecting to those coming in on this hearsay within hearsay argument on the basis I described. So let me pause for just a minute. Why didn't he start out with the numbers? He's giving a couple of examples. So I think before he was trying to do an argument, his argument wasn't strong enough. So now he's saying, well, let me show you some examples of what I'm talking about. My argument's not enough. Let me show you some paperwork. So before we go too far, because we've got this phrase in here, hearsay within hearsay, which sounds ridiculous to normal people. Let me just tell you where that comes from, so you can see what we're talking about. All right, hearsay within hearsay. We have a rule called hearsay within hearsay. I know it's ridiculous. Hearsay within hearsay is not excluded by the rule against hearsay if each part of the combined statements conforms with an exception to the rule. That is the hearsay within hearsay rule. So if there's hearsay, multiple layers of hearsay, it can still be allowed in so long as each piece has its own exception. All right. That would be on your law school exam. That would be like 2 hours of writing. Right there. All right, everyone's getting A's. All right. So the judge is saying, Mr. Pecker, I understand. Okay, here we go. Hearsay within hearsay argument on the basis I described. Mr. Pecker, I understand, comes in. Mr. Howard's statements are inadmissible hearsay, but they're admissible to provide contents to what Mr. Pecker said. 171A, for example, is a series of messages between Dylan Howard and Gina Rodriguez, with factual assertions being offered for the truth, so we can address them in real time. We raised this yesterday. We sent the people more objections last night at 8 o'clock. I respect the people were observing last night. Whoa, wait a minute. I respect that the people were observing last night. How's that relevant? And the state says, I know. I understand the timing of this. we'll continue to communicate with them on it. What I would ask for this afternoon, when we're short on time, I've identified 2 strings where the witness is on the stand, that we cover those and we talk a little more about the others. And the judge says, I appreciate that, thank you, whereupon the following proceedings were held in open court. Your objection is noted and overruled. It's overruled. Overruled, you're done. The documents are accepted into evidence as business records. To the extent that they may be any embedded hearsay within them, we'll deal with it as it comes. Thank you, Judge. Whereupon the aforementioned people's exhibits were admitted into court. It just cracks me up. It just cracks me up, everybody. A good judge makes all the difference. All right, so before I start getting into the next batch, did everybody follow me down that rabbit hole? Did everybody follow what we were doing there when it came to the hearsay? That was really what I wanted to kind of take everybody down through the, what we have to deal with in court. I mean, this is real court situation. Okay. So you have to know your rules. You've got to figure out, are we using hearsay within hearsay? Is it not hearsay? Is it an admission by a co-conspirator? Is it admission by a defendant? Is it one of the 27 exceptions? So that's where all of these things can fall in. Now, this defense is going to be using hearsay over and over and over again throughout all of the rest of the direct here. He's going to be objecting to hearsay to all of the witnesses, the other 2 witnesses that came in that have already testified. So I thought this was a really important foundation to have, so that when you hear the testimony coming in and what defense does in the future, you'll understand what they're talking about now. So when you hear that, now you'll know where it's coming from. Couldn't figure it out on your own. Well, I mean, it's ridiculous. It's complicated. It's complicated. It takes a lot of trial work. It takes a lot of trials. And when you're in trial, you screw it up, and a lot. The only way you get through hearsay in trial is just to memorize all the exceptions. I got to a point where I didn't even say the numbers anymore. I was just like leading, or I was just like, no personal knowledge. It didn't even matter. I would just shout out the name of the rule, and they'd be like sustained or overruled. You just get to that point now, once you've done it for so long, that you don't even need to do it anymore. Law school. I'm so glad I decided not to. Oh, Amber. Well, there's lots of reasons to go. Lots of reasons to go. And, the content, and one thing I would say too is, it's not the material in law school. I think, anybody could sit down. Well, I mean, I don't know if anybody could, but if you are truly determined to make something happen, you can do it. But it's not just what's in the books. And I think that's one of the things that some people get tangled up in when they're trying to represent themselves. They kind of think, well, if I just find whatever's in the books and read what's in the books, then I'll be able to do it. And sometimes that'll work. Most times, you're going to have a good start to it. But, there's a lot more behind all of this than just what's in the books. You're in law school, Hitch? Oh, good for you. All right. Have you taken evidence already? Oh my goodness. It's the argument. It is. But it's the argument, but it's also being able to be able to formulate the argument around your rules. You've got to have your, not just your rules, but your argument has to be kind of woven in there. Mock trial club was fun. Yes, I think mock trial is really fun, but I would have to say, in my humble opinion, mock trial and real trial are just 2 different worlds in my opinion. Now, mock trial, they set out the rules that you have to use, the jurisdiction. They really kind of set everything up. It's more of a drama situation than a full-on trial, because there's no way that you can truly understand the fear and pain of being in trial unless you're actually in trial. Hold on, everybody, my battery. Oh, my battery. Hold on, here we go. Is it going? I'm on my 3rd pack. Here we go. All right, it's back up. Is it back up? I don't know. Oh no, everybody. Hold on just a minute. It's still not quite charging. Oh. All right, it's charging. Sorry, everyone. Woo. There we go. Okay, we're back. We're back. I've been working so hard to not lose my battery on my lives, everybody. Woo! Oh my goodness gracious. Anyway, all right. So the point is, mock trial is an amazing tool. Absolutely. Absolutely. But you have to go to like the top of the tallest building if you have a fear of heights, and that'll truly give you the vibe for what a trial is. Foreseeable possible objections. Yes, I would absolutely. See, when putting together a case, it's hard to just see your case from, for me at least, when I put cases together, is you put them together and you immediately see the holes in your own case. And by seeing the holes in your own case, you see what those objections are going to be. You see like, wow, this could be an objection for hearsay, or this could be an objection for relevance, and then you figure out how you get around it. So how you would argue it. I also, during for depositions, during different testimony, one of the things that I would do is I would do what I just did here, which is, write out what rules were going to be a problem, and just say, well, what rule am I going to be issue? What thing am I going to be dealing with here? This is going to be a pattern establishing issue. Is this going to be an alibi issue? Is this going to be a hearsay issue? Those kinds of things. And so for me, I kind of would make those kinds of marks in my own notes. That's how I was, just because I'm very visual. So that worked for me. Other people had different ways of doing it. I knew someone that just brought in a yellow legal pad blank, and he could do his whole trial off of that. I mean, of course he had his trial, catalog put together. He had all of those things he needed, but he just needed a yellow blank piece of paper, and he could go forward off of that. That's all he needed. He made his case as he went because he knew his case so well. But you should be able to predict what your objections are going to be, and try to figure out, what the answers are going to be. Sometimes you're going to win, sometimes you're going to lose. And sometimes when you lose, it's really painful. Oh my gosh. There are many times where you go forward and you're like, well, Your Honor, what about this? Nope. What about this? Nope. What about this? Nope. I'm like, fine, I'm going to lose it. And then you have to go back and figure out how to figure your case out without that piece. Without that piece of evidence anymore. You're like, oh, well, I lost that. I'm going to have to figure it out. But yeah, I mean, you got to kind of think quick on your feet, but on the one hand. But then on the other hand, too, you get to a point where you're just so used to doing it. I think sometimes trial attorneys, if they're trial attorneys, we just learn as we go, and we remember every single mistake. I feel like I remember every single mistake from the time that, an authoritative figure told me I needed to switch to decaf. Like, you need to switch to decaf. You're getting a little too wound up for that closing. Like, wow, you remember it. So you just, it's a lot of fun. But anyway, so with that, everybody, that's kind of, I probably won't do any more reading for tonight just because my battery is so hot. But I hope that gives you a little bit of insight, though, into the kind of trial work that is in a criminal court. Now, civil court's a little bit different, everybody. We don't have in civil courts, we're careful, we're very precise, but we don't have the same, we don't have the same stakes, honestly, and I'll just put it that way. Like, you may think, well, it's a $5 million suit. True, and that's somebody's livelihood. I get it. But there is a distinct difference between going in on a civil case where you have some kind of harm that's been done and your heart breaks for that person, as opposed to if you screw your case up, your client goes to jail, goes to prison, or worse. And there's just something about that. I mean, it's two different worlds. It really truly is two different worlds. But yeah, I'm not trying to say one or the other than, you look at somebody who, you did everything you possibly could and they still went to prison. Yeah, that's a tough one. But, you do everything you can. That's all you can do. And if the prosecutors have the evidence and they have the law and everything is done properly and you do everything you possibly can to help your client, your job is to not have them go free. Your job is for them to have a fair and proper trial. So if they go to jail, then they go to jail. You still did your job. So highest stakes, absolutely, absolutely. But that's the thing, is our job as defense counsel is not to get our clients off. That's not our job. Our job is to make sure that their rights have not been violated and that they have every single step along the way a proper trial. So yes, so with that, everyone, with that soapbox, oh my gosh. Well, this was really fun tonight. I appreciate it. To my sub chat, I really appreciate you walking with me down that road. I really, like I said before, I don't like to go too in depth into the technical issues on a lot of things, but I figured if you were coming to hang out, we could do it tonight. So you would have a little bit of a basics to kind of take with you. So it's been awesome. Oh, okay, good. I'm so glad. I'm so glad. Now, tomorrow we don't have court, everybody. We do not have court tomorrow, so we will not have that. Now, the transcripts that were made available are only of Mr. Pecker. I do not have the next witnesses. They just haven't put them up yet. So I'm kind of just refreshing and waiting to see when I'll have those out. But tomorrow, everyone, on Monday, I am planning to be back 7 o'clock Central, and I want to go through the Arizona indictment. So that is my plan. I will post in the morning to confirm that as well. But my plan then is to read through the Arizona indictment for tomorrow, and then we'll see what the rest of the week holds, depending on how things come together. So, yeah, oh yeah, absolutely. Yeah, Arizona is fascinating. That's a really interesting, or the Regal Light case, as I'm having fun calling it. Yay! Oh yes, Arizona, I think, they did a great job. They did a great job. Very, very pleased with what they did. And you can see that they really took their time. I'm not saying Georgia didn't. I'm just saying it's a different animal. So, with that, I'll go ahead and sign off for now, everybody, before my battery goes completely melted. But thanks for coming, everybody. Thanks for hanging out. I'll have my regular chat back on tomorrow at 7 o'clock Central. We will go through the Arizona indictment. So thank you all for coming and hanging out. And thank you so much to my subscribers. I appreciate your support so, so much. I'm very thankful for all of you. So take care. Have a wonderful rest of your night, everybody. And I'll see you all tomorrow.